Good morning, everyone. Thank you for joining us for the first part of our federal contract termination checklist with our expert instructor, Evan Sherwood from Denton's. He has put together this presentation, so we are happy to have him here today. He will be guiding us over the next 90 minutes, and then next month, I believe it's August 27th, for the second half of the series, will be another 90-minute block. We're going to have some passwords and polls throughout today's session, so when those passwords pop up, please make sure you write them down. When those polls pop up, please make sure that you just answer them to the best of your ability. Most of them will be kind of open-ended, so feel free to put your answers into the chat so we can discuss a little further. If you have any questions about passwords or certificates, feel free to email me. My name is Josh. I probably should have led with that. My email address is joshpina@publiccontractinginstitute.com. If you have any questions about CLE, you'll be reaching out to Joshua Lee. So that's JOSHUALY at publiccontractinginstitute.com. Without further ado, Evan, I have talked for way too long. The floor is yours.
All right. Thank you very much, Joshua. Hi, everybody. I'm Evan Sherwood. I am a partner in the Government Contracts Group at Denton's in Washington, D.C. I do federal contract law, including cost accounting, claims and disputes, contract terminations, and federal contract counseling generally. There is my picture and contact information. The topic today is federal contract terminations, which is, of course, a very timely topic you've probably read about in the news, because the federal government has been terminating contracts at a rate that just really has not been seen, and it's a sort of policy-driven effort from very high levels of government to take a hard look at existing contracts and the need for particular contracts. And there have been executive orders starting right at the beginning of the administration directing termination of certain kinds of contracts, as well as grants and cooperative agreements, and directing reviews. So, I won't go into the news that I'm sure everybody has read about, say, the DOGE review process that the government kicked off. But the bottom line is that the government's been taking a hard look at contracts and has been issuing terminations. And so companies have been finding themselves faced with the questions of how do you handle a contract termination, companies that would not have expected themselves to be in that situation. So given all of this, that's the topic for today. Is if you find yourself at the receiving end of a termination notice for one of your federal contracts, what do you do? Because it's complicated, right? And you may have opened Part 49 of the FAR. We've got the book right here. It's a big, complicated book. It's not the easiest thing to read, and it's not the easiest thing to apply. And so we want to talk about sort of what this means in practice, give you some practical tips, and at the end give you, frankly, a checklist to run through, because I think it's helpful to reduce things to some straightforward steps. So Josh, if we could go to the next slide, and we'll kick things off with some of the substance here. Joshua, are you able to advance to the next slide? Thank you. All right, so we want to start with what I see as a really fundamental question, which is, when does the government have authority to terminate a contract? For a lot of people, particularly new to government contracts, it can be surprising that your counterparty actually has authority to terminate the agreement, to tear up the agreement and say, we're not doing this anymore. The government has two basic flavors of termination authority in most of its contracts. There's some exceptions, we'll get into that in a minute, but there are terminations for convenience and terminations for default or cause if you have a commercial item contract or commercial product service contract. Terminations for convenience are what they sound like. The government has the option to terminate when it has these clauses in the agreement for its convenience, in the government's interest. And there's not a lot of bright line rules about what that means. It's a very broad termination right where these contracts are here, and it's very difficult to challenge that. But fundamentally, what a termination for convenience is the government saying it doesn't need the goods or services anymore. To go with a breakup analogy, they're saying it's not you, it's me, right? They're saying they don't have the need for it anymore. Terminations for default or cause are where the government is saying the contractor did something wrong, something contrary to the contract, and the government wants to terminate the agreement for fault. In other words, it's not me, it's you, right? So those are the two basic flavors. Now, if the government's going to terminate for default, it needs to establish some kind of cause or default. So the bar for terminating for default is higher than the bar for terminating for convenience. And in fact, if the government wrongfully terminates for default, what the standard FAR clauses say, the FAR default clauses say, is that the termination can be automatically converted to one for convenience. Okay? So this termination for convenience right is really broad because in a lot of cases, it even backstops the government's termination for default ability. So we've got on the screen a couple examples of the termination clauses that you might see in a contract. So in a standard fixed price non-commercial contract, talk about what commercial versus non-commercial is later, but just bear with me for a moment. You'll see the FAR 52249-2 clause. If you have a cost reimbursement federal contract, you'll see the 52249-6 clause. If you have a commercial product or service agreement, that's where the government buys things. Just to get into that now, that's where the government is buying a product that is generally available to the public or that's been offered or sold to the public. There can be some minor modifications, et cetera. It could be a whole topic of discussion. What is a commercial product or service? I'm not going to get into that now. Just suffice it to say there are streamlined procurement rules for when the government is buying commercial products or services. And if you have one of those agreements, you will probably see the FAR 52212-4 clause. But all of these have a termination for convenience right in them. Now, you might see other versions too. Sometimes the government puts in a tailored version. There's a version for construction. There can be a version for services. But you're going to be looking for one of those clauses to see what's there if you get a termination notice. The termination for default clauses I also have here. In a cost reimbursement contract, it's actually just one termination clause, 52249-6, unless it's tailored, which again sort of speaks to the breadth of that clause and gets into the nature of cost reimbursement contracting. So recently, the terminations that the government's been issuing by and large on these sort of policy level, policy-driven terminations are terminations for convenience, what we call T for Cs. Okay, that doesn't mean that, and what that's saying is the government is making that, it's not you, it's me determination and terminating the agreement for that reason. Okay, now the government, when it issues a termination, should say what its source of authority is and its grounds for termination. So it shouldn't really be a mystery to you. But what happens if it doesn't? Well, it can get a little complicated. Again, the government should do it. And it's really in everyone's interest for the government to be clear about why it's terminating and on what grounds. But if it doesn't specify, the sort of default assumption you could take, and it would be something you would want to pursue, just to be clear, you wouldn't just necessarily want to do this in the abstract. But if the government isn't specifying a determination for default, then presumably the government's only other basis then would be a termination for convenience. Since the bar on default is quite high, it would have to specify a default. In that situation, you're going to want to think about how do you communicate with your contracting officer to address the issue. Maybe it's a simple message, hey, we understand this is a termination for convenience. There might be situations where you want to ask what was the basis for it. But you're going to want to think about, before you get into the next steps of what to do after a termination, whether it's for convenience or a default. So that's a real sort of fork in the road early in the process. Joshua, can we go to the next slide? All right, so what are your basic options for responding when you get a termination notice? Well, there's a lot of potential responses. The nuances are endless, but for simplicity's sake, we're going to put them into two buckets. You could challenge it, try to dispute it, or comply with it. Right? Those are sort of your basic legal options, challenge or dispute. A challenge can take different forms. That could be requesting that the government rescind the termination or treat the notice as ineffective. You could try to dispute the validity of it if you think the government has no basis to terminate, or proceed to prepare a claim for contract damages or to challenge it. We'll talk about that more in a moment, right? Challenges can be tough for reasons that I'm going to get into. The government has a lot of authority to terminate agreements, particularly since it's got that termination for convenience authority. Disputes over the validity of termination are usually come up in cases where the government's terminated for default and the contractor thinks that's inappropriate. And of course, termination for default comes with the added risk of sort of damages to a contractor or reputational risk. Terminations for convenience usually give the contractor a right to claim some degree of its costs, and we're going to get into that. It's going to be most of what we're talking about here, the costs and in many cases profit a contractor can claim in the event it's terminated. So, that goes over to the comply part. If you're not going to challenge it, then you got to comply with it, or at least assess it for compliance. And there may be parts of it that you respond differently to. But again, the two basic options are challenge or comply. On the comply side of the ledger, you're typically going to be using your termination for convenience clause as your roadmap for what you do next. And that basically comes down to complying with the notice, stopping your costs, preparing a termination settlement proposal, and winding up performance. So those are your two basic options. I want to start with a brief discussion of challenging termination notices. So Joshua, going to the next slide, we're going to start with that. So if you challenge, what are your options for challenging? Well, I want to focus on terminations for convenience right now, okay, because that's been largely what's going on. So that's what we're talking about here. We're not necessarily talking about terminations for default. So a termination for convenience, the clause says the government gets to terminate in its interest, right? That's the basic rule. So it can be difficult to challenge a termination for convenience because of that sort of starting point in the clause, but it's not necessarily impossible. It's difficult, it doesn't happen often, but it's not impossible. And what are some of the things you're going to want to think about if you find yourself in that situation where you're considering a challenge? Well, one is there a termination clause in the contract? It seems like a simple question, but it's worth asking. What does the contract actually say about the government's right to terminate? And if there is no clause, what does that mean? Well, in your standard procurement contract, that's a contract where the government's buying goods or services for its own use or benefit, and I'm distinguishing that from grants and cooperative agreements, which we're not talking about right now. We're talking about contracts, procurement contracts. If there's no termination for convenience clause in the contract, there is a doctrine that says a standard termination clause can be read in, meaning even if it's not there, you can treat it like it's there if certain circumstances are met. Those circumstances are, I'm going to summarize here. There's a lot of doctrine here that I'm just going to try to bring down to a basic point. The circumstances are essentially, is there an applicable regulation, say in the FAR, that would have required it? Like, in other words, did the government miss it on accident? If the government had been thinking about it, the FAR would have directed them to put it in. The other is the clause sort of fundamental to procurement policy? In general, courts have said termination clauses are, but there are certain types of agreements that don't traditionally have termination clauses, for example, federal leases. And so the absence of a termination clause is not necessarily, I wouldn't say it's automatic that it gets read in, but it's very likely under the doctrine of GL Christian and Associates that a termination clause can be read in, even if it's not in your agreement. So that's a starting point. Is there no termination clause? If not, you want to think about that, because if there isn't a termination clause, and if one can't be read in, well, then maybe it's not appropriate for the government to terminate for convenience. To be clear, that's not going to be a super likely outcome. I'll say in a lot of cases I would not expect, in most cases I would not expect that, but it's worth thinking of. Some of the other things to think about are there any procedural defects? Say you got a notice terminating your contract, but it's unsigned. Well, I think most people are familiar with the concept that your contracting officer is the only person empowered to make contract determinations and contract decisions for the government. And so if you get a termination notice that isn't signed by a CEO, or worse, doesn't even reference your contracting officer, and I'll just say, early in the days of terminations earlier this year, some companies were getting termination notices from people that were not their contracting officer, and they had to think, well, what's going on with that? That can be an issue because it's supposed to be the contracting officer. The standard clause says the contracting officer has the right to terminate. You will sometimes see clauses that say the government instead of the contracting officer, but typically it's the contracting officer. You can also ask, did the CO use independent judgment? Like, in other words, did the CO actually make a determination of what's in the government's interest? Because if neither of those things are present, you've got some grounds to potentially dispute a termination notice. Now, I'm going to talk about on the next slide, just to give you a quick preview, these kinds of procedural defects can often be easy for the government to fix. So if you find them, it doesn't necessarily mean you get to ignore your termination notice. Okay, we'll talk about that in a second, but I'm just going through, are there points to ask where you might want to go, hey, government, I got a termination notice, but it wasn't signed by a contracting officer. What's going on with that? The last point is bad faith. So the courts have said that when the government terminates for convenience, it should act in good faith. It cannot, in other words, terminate. And if it does, that can actually be grounds to dispute the termination. But that's a really high bar. The courts have said they've got some lofty language about what a high bar that is, and the government actually receives a presumption of good faith. In other words, the sort of starting assumption is if the government did something, it did it in good faith. There have been a few examples over the years. The digital text case that I have here is an example of that, where a contractor has successfully pled that a termination was in bad faith. That means, and the sort of facts that can get you there if the government was terminating deliberately to harm a contractor, or specifically because it wanted to, get a better deal than the one it negotiated. Those are the sorts of things that can start to open the door to a bad faith termination claim, but it's a very high bar. So, all of these things here, what does it get you, even if you can establish it? Because we got to talk about, even if these things are here, what's the practical import of that? And Joshua, if we go to the next slide, we're going to talk a little about that. What is the practical impact if you can establish one of these things? Well, to talk about that, you have to talk about your procedural options, right? So there are various federal laws that talk about the kinds of claims you can bring to challenge government action. One of them is the Administrative Procedure Act, which says that a court, just to back up a moment, it establishes a baseline that the government's actions should be compliant with law and well documented and not arbitrary and capricious. In other words, it needs to have reasons for what it's doing, right? The government cannot act arbitrarily. And if it does, a court can actually enter an injunction, which is a binding order to correct the government's violation, okay? But there's a bit of a divide in the law here. The APA, the Administrative Procedure Act, can get you injunctive relief. But if you want money damages, if you want to be paid money, then under a procurement contract, you need to make a claim under the Contract Disputes Act and the Tucker or the Contract Disputes Act, which gives you an option to appeal to a Board of Contract Appeals or the Court of Federal Claims, okay? The Court of Federal Claims has jurisdiction through something called the Tucker Act. The CDA runs through the Tucker Act. I don't want to get into the jurisdictional stuff. That's fun for lawyers. It's not really fun for anybody else. The reason I'm bringing it up is under the Contract Disputes Act, at a Board of Contract Appeals or the Court of Federal Claims, you can't get injunctive relief. You can get money damages, and those courts and forums can decide legal issues on the way to a money damages judgment. But if you want injunctive relief, that's under the APA. Now, you can get declaratory relief. You can get a contract interpretation at a Board of Contract Appeals or the Court of Federal Claims. But if you're looking for that injunctive, that binding order relief, that's the APA. And there's a bit of a quagmire here in the jurisdiction, because some courts will say if the bottom line result is a contractor wanting money, then it really should be a CDA or Tucker Act action and not an APA action. So you've got to think about what are the harms you've experienced. Total termination of a contract improperly where there's no grounds to terminate can have non-monetary impacts. So in that situation, you may have an APA claim, and there have been some cases recently where courts took jurisdiction under the APA to review challenges, but you've got to think about it. And this gets to the bottom line. Like, you can establish some of the things we were talking about. Maybe the CO didn't sign your notice, and that seems like a problem to you. Well, those kinds of issues can often be easy for the government to fix. Okay, so if you bring an action and say, hey, this notice wasn't signed by the contracting officer, well, the government can go, okay, we'll find a new contracting officer and have that person fix it. So that kind of challenge can buy you time and force the government to maybe redo its action, but you have to ask yourself, is the forcing mechanism of that actually going to lead to the bottom line result you want? Or is the government going to be able to find another contracting officer who can validly terminate? Because in that case, then maybe the upside of the action isn't that high, right? But you got to think about that. You got to think about, bottom line is, are any of these procedural defects that the government could cure or take corrective action on in a pretty easy way? If you have something that you think is contrary to law, like let's say you've got a regulation or a statute that you think prohibits the government from taking the action it's doing, that could be a stronger APA claim because it's harder for the government to take corrective action if what you're saying is a statute or regulation forbids what they're doing. So you got to think about that, the practical import of it. Going on to the next slide, there's a little bit more to discuss on that. Joshua, could we go to the next slide?
Yes, Evan. Oh my gosh.
Joshua, are you there?
Sorry, how does my audio sound now?
Good. There was
Okay.
a little echo there a moment ago.
It was an insane echo on my side, so sorry about that for everyone. We do have a couple of questions here, and then we can throw up our first password. And I do have a question for you. So I have this up on two computers here. Did you see the slides drop off at any time?
I did not. The slides have been present for me the whole time. I don't know about the audience.
Okay, if it's showing correctly for you, it should be showing correctly for everyone else. Someone did also say that they couldn't hear any audio in the beginning. I believe that might have been a one-off also.
Okay.
So I'm going to put up our first password now, and then do you want to hit these questions or the questions from the attendees first?
Let's do the questions from the attendees, and then we can get into the first question.
Okay, too easy. So our first password for today is koi, as in koi fish, capital KOI. Koi is our first password. If you are seeking credit, please make sure you write down these passwords today because that will be how you receive your certificate for attending. If you're just looking for a certificate of completion/attendance, then you will get that automatically from GoToWebinar roughly 24 hours upon completion of the training. So I'll leave this up for about 10 more seconds here. And then the first question I have here, Evan, is how do we know that the CO did not use independent judgment?
It's a great question. There's not an easy way to know. You're probably going to have to look at your letter, right, and see what does the letter say about it, and think about some of your communications with the CO. So an example might be, and I say might be, every one of these things is going to be really fact specific, okay? But let's say you talked to your CO after you got a letter from the CO, and the CO said, somebody else gave me that letter and told me to send it to you. Right? If the CO is basically telling you, like, I'm just passing along something from somebody else, well, then I think you might want to ask some follow-up questions to understand, did the CO actually exercise independent judgment here, or did the CO just forward along a letter? That is an example, though, of something that's a procedural defect where, even if your CO didn't necessarily use independent judgment at the time, if the CO goes, well, I've now thought about it and I agree with the notice, this is, I'm adopting it, this is mine, and that's going to get you into a different situation potentially. But that's, you're going to have to look at the facts and circumstances. There's not like a single way to know whether the CO used independent judgment. So I think that was one question. Did we have another?
We did have another. The next question was, can a company invoke the APA and CDA simultaneously?
That's a great question. So I am going to have to mind myself because I, as a lawyer, think there's a lot of really fun and interesting questions. You'll have to forgive me for being excited about the law, but a company can potentially invoke both. There's often uncertainty, and there can be genuine uncertainty on a particular claim, on particular facts about which remedy makes the most sense and which remedy a court might actually accept, because it's possible you can go to one court and that court says, actually, you got to go to the other. I'm not the right court. I think this is the other. So there's strategies you can use in those cases to preserve both claims and pursue them at the same time. I'll sort of leave it at that. If you find yourself in that situation, you're going to want to navigate that very carefully with counsel. Again, the answers to that are largely jurisdictional, and I'll just give you one more point on that. There's a statute at the Court of Federal Claims that says if an action is already pending in district court when it's filed at the Court of Federal Claims, then the Court of Federal Claims in some circumstances doesn't have jurisdiction. So you may want to sequence it on where you file first to help with that if you're not sure which remedy you want. But you want to start way at the beginning with thinking very carefully about what's your best argument, what's your remedy for, and that depends a lot on the contract terms, all right, what's actually in your contract, the harm that you're going to experience, all right, what sort of harm, what's the relief you really want at the end of the day, and the circumstances giving rise to the issue, right? What has the government done? All of those things can send you in different directions. And by the way, these questions are great. And I'll just say, as a presenter, I love getting the questions. It helps with the flow of discussion. And that way, it's not just me talking nonstop the entire time. We can have people's questions coming in. So please, if you have questions, I encourage it. Love to answer the questions. And I can see on my screen, I can see some coming in. But Joshua is going to let me know as they come in. So he can jump in and read the questions as they go. I also have a question that I put on the screen that I'd be very interested to see, to talk through. I want to give everybody just a moment to think about it. I know this has been on the screen for a few minutes, but let me just read it while we all think about it together. So, contractor receives a termination notice, but it does not specify the ground for termination. What is the significance of that? All right, suppose you get a letter that says contract is terminated, but it says nothing else. What's the significance of that? If anybody wants to answer by chat, that is great. Otherwise, I can just go right on in with an answer. Oh, okay. I see Joshua's got a prompt that's popped up. That's great.
Evan, we did have one more question that came in that we can hit after we do these two questions as well. So I do have the prompt up. Feel free to put your answer directly into the questions section. If you did already, feel free to go grab a drink, snack, or something while we give everyone else a couple more minutes or so.
Okay, it looks like everyone has responded. So I'm just going to proceed with the question, if that makes sense to you, Joshua. All right, so what's the significance of that? If the government doesn't specify, well, it needs to specify. It's supposed to specify so you can understand what grounds it is invoking, because your rights are going to be different if it's a termination for default versus a convenience. If it's not specified, then one approach is to tell the government that you don't think that you understand it's a termination for convenience, right? That's one approach you can take for it. But you might also want to look in that situation, take a hard look at some of the procedural issues. Is it signed, right? Does your contract have a termination clause? Does your termination clause specify any kinds of procedures, right? So those are all things to look at. And I did see there was a question that came in about, can the government issue a termination by email? Well, unless your clause specifies something really specific about the format for the giving of notice, a writing by email will typically suffice. And again, even if for some reason it didn't, your clause, say, required the notice to be given by, signed letter delivered first class mail, well, in that situation, that's something the government can usually correct pretty easily. So you wouldn't necessarily want to ignore it in that situation, but you want to take a hard look. Now, suppose the termination notice is unsigned and there's no clause in the contract. Well, that gets back to that GL Christian and Associates doctrine that we were talking about a few minutes ago. You want to take a hard look at that and see, is this the type of agreement where a termination clause can be read in or not? Now, I'm just going to scroll through some of the answers, and I think people are sort of getting the point. And I really like, there's somebody made the point about begs the question of why perhaps a call to the client is warranted. And I think that can make sense. Often you want to ask for more information, right? So getting more information, very helpful. If you find yourself in this sort of situation, there's not a one size fits all answer, right? It fits you want to proceed along the lines that we've just discussed. Okay, let's go to the next slide.
We did have some answers for the second question as well. Did you want to go over any of those answers or just straight to the next slide?
Here, let me, looking at this, I think some of these answers are really spot on, right? Requesting cause can make sense, right? If you request the cause, you could be sort of inviting the government to to elaborate on its position a little bit more. But then again, it could always do that. So I think there's a judgment call. It depends a lot on your relationship with your customer about what you want to say when you get back to them. Is it we understand this is a termination for convenience? Is it we're not sure and we need your guidance? It fits somewhere along those lines. So with that, I think we can go to the next slide.
Sorry, there is a slight delay. You should see the slide popping up now.
Okay, no worries at all. All right, so we're going to have a checklist at the very end, but there's a 3-point checklist for responding to a termination notice that I want to think about now, right? So we're getting into the compliance part, right? So let's say, you don't find grounds to challenge. You've got a termination for convenience, and you're concluding to yourself, hey, we don't have grounds to challenge this. Well, then you need to comply with it, right? And the basic steps are going to be in your clause, which I've boiled down to 3 points here. Again, you always want to read your contract. Always read your contract. Step 1, if you get a termination notice under FAR Part 49, is to stop work and reduce your costs. And actually, Joshua, could we jump forward a slide for a second? I think it would actually help to take a look at that next slide just very briefly as we go through this. Is it on the next one, Joshua, the slide with the FAR 52249 clause?
It is the next slide after that. It's just taking us to
Okay, all right, got it. Yeah, so let's take a look at this clause for a second, everybody. So this is your standard termination clause in a fixed price non-commercial contract, all right? And what it says is you need to stop work and begin winding up operations, okay? And what you get as the contractor under that clause are a few things, right? It's not that the government gets to say the contract's done and walk away and this is all over now, you have no rights. It's not that. The contractor has rights. The rights are laid out in the clause, and I've summarized them here, okay? This is just a summary of what they are. You get the contract price for completed work not previously paid. But you also get, and this is key, and this is what we're going to talk about largely for the rest of this presentation, is reasonable costs incurred. You get costs, okay? It essentially converts your agreement, whether it's a fixed price agreement or a cost type agreement, into a cost-based agreement where you claim costs of work plus certain costs of settlement, and the government is entitled, or the government is required to pay it if you meet certain standards. So reasonable cost incurred is what you get. For performance of the terminated work, which includes your initial and preparatory expense, your cost of settling and paying terminated subcontract proposals, you get your reasonable cost of settlement, that's preparing your settlement process, your settlement proposal, which can include expenses of any outside accountants or outside legal counsel that you need to prepare. The government will actually include that as a settlement expense. You then get fair and reasonable profit on some of those costs, some of the costs that are eligible for it. We'll talk about what costs are eligible for it. So again, the basic idea here is your agreement is converted into a cost type agreement. So Joshua, with that, if we could go back 2 slides, and forgive me everybody for going out of order here, but just as we went through this, I thought it would make sense to start with that. So when you get that termination notice under FAR 52249-2 or equivalent type of clause, there's 3 things at base you're going to want to do. Stop work and reduce costs, take stock of any property you have that the government may have an interest in, and begin your plan for preparing a settlement proposal, a termination settlement proposal, which is a really key document. That's where you claim your costs. That's where you propose to the government what you think you're owed as a result of the termination. So on item 1, you want to take immediate steps to stop work. Okay. There is a basic concept in the law of mitigation of damages. In other words, you sort of can't run up the bill, can't run up the damages when you have the ability to stop them. So you want to do what you can to stop work. You get to take reasonable steps to stop work. And as we'll discuss in a moment, there may be things you are doing that you cannot just hit pause on. You can't just hit the stop button. Some things require a wind down. And so in those cases, you want to take reasonable steps to start that wind down. You want to do what you can to reduce costs. At base, you want to put yourself in the situation to say to the government, or if you're in a dispute later, a board or a court, hey, I acted reasonably. I did what I reasonably could to reduce my costs. Okay. That also includes terminating subcontracts and vendors as necessary and appropriate. So if there's subcontract or supplier agreements that you have supporting work and you don't need them anymore as a result of termination, the government's expectation is that you were going to do something about that, right? That you were not going to just continue to incur those costs, at least not charging them to the government. You may decide you still want them for other reasons. That would be different. We can talk about that. You also want to track your costs. This is key because particularly if you're working on a fixed price agreement, you may not have been doing that. You may not have had to report costs, and so you might not be tracking them at the level of detail that you're going to want, ideally, in a termination settlement situation. So for example, if you have employees who are going to be working on administering the termination, you may want to set up a separate charge code for them. If you have outside support you're getting, there's legal counsel or accounting support, you're going to want to track those costs because tracking of the costs is going to allow you to put you in a stronger position to claim them later. The standard termination clause, again, 52249-2 is the one we're using as the example here, says that the contractor needs to manage, I'm summarizing here, but manage property that the government may take an interest in, because the government may direct delivery of property, it may direct return of government furnished property to the extent you have some. So you want to take steps to protect that property. You may want to ask your contracting officer for instructions about what to do with it. It all depends on the sort of property you have, and you want to be mindful of any kind of credits or adjustments that you may have earned or maybe along the way in managing property. Finally, this last point is key: prepare the termination settlement proposal. The FAR clause contemplates that a contractor will submit a termination settlement proposal. And there are specific standard forms that you'll want to use in doing that to help the government process the termination settlement proposal. And again, your settlement proposal is essentially your request for payment. You can think about it much like a proposal for a contract, but it's a proposal to settle a contract. It also procedurally sets up your claim later if you have a dispute with the government and you need to pursue a claim for damages. To prepare that termination settlement proposal, you're going to want to settle with anybody else whose costs you're including in that. So you may need to have termination settlements with your subcontractors, and you may need to negotiate those. Well, those are going to be included in your proposal. Those are your costs that would go in your proposal. So you want to sequence things to settle with subs first, or settle with anybody else who you're trying to flow, where you have a dispute that's going to lead it to costs into your settlement proposal. So you want to sequence those things. And you want to be mindful of the deadlines. In the standard FAR clause, the deadline to submit your termination proposal is 1 year after your contract is terminated. 1 year, okay? Which means in your subcontracts or vendor agreements, you're going to probably want to have a timeline that's faster than that so it can be included in your settlement proposal. Always check your contract. Always read your contract. Some contracts may have a different deadline. It may be less than a year. It may be more than a year. FAR Part 12 commercial product and service agreements don't by default have this 1 year deadline. Should still move forward with deliberate speed, but again, check your contract to understand what is the deadline that you are actually facing. Okay, so those are the 3 key points, and now we are going to dive in more detail into what they mean. Joshua, could we go to the next slide? All right, great. So I want to start with the settlement proposal, that 3rd item, because it is the framework for where you go from there. A termination settlement proposal is what it sounds like. It's a written narrative with your supporting data, any necessary forms, that explains to the government why the contractor is entitled to payment. Okay? And you want to be very mindful of the audience here, knowing that this could lead to a dispute, but ideally not, right? Ideally, you'll be able to settle with the government, and most of the time, terminations are in fact settled administratively. That's sort of the normal path of this. And you want to put yourself in the situation to get there. So you want to explain, you being the contractor, the reasons for your entitlement to the amounts you are claiming. All right. What's the law? What are the facts? What are the provisions of your contract that require payment to your firm? And you want to make it easy. And I think a lot of government contracting officers and government counsel will say, look, they're not looking for a dispute. They just want to understand the position. And if they get a proposal that doesn't explain entitlement and they're left to figure it out, well, that makes life very difficult for them. So you want to make this easy. You ideally want somebody to read your proposal and go, I understand why the contractor wants each item of cost they're claiming. And you also want that person to read it and go, I understand why the number they're claiming makes sense. And the why on the number is generally about the financial data. What are your costs? How were they recorded? How do we know they're right? The stronger position you can put yourself in there, the better off everyone is going to be in reaching a settlement without a dispute. And I can tell you so many of these things that do go to disputes, the disputes arise out of confusion at this stage. Confusion and uncertainty about what's being claimed, about the amount claimed, so by putting your best foot forward here, you can make life easier for everybody, for you, for the government, and avoid a disputes process, right? Which is where this thing would go if the parties can't settle. So on that, being mindful of your proposal process is really key. And I just want to foot stomp something here, and I'll say a few more I think I've said before, and you'll hear me say it again. The government, under the standard FAR clause, will compensate a contractor if it needs outside assistance to prepare its proposal. So if the contractor wants to bring in outside legal counsel to advise on that, your outside legal counsel fees can be allowable. If you need an accountant or a cost consultant to help you organize the data in a way that makes it understandable and easy for the government to read, that the cost of having that outside consultant can be allowable. So take, as a contractor, think about that as you're going through this process. Are you going to put yourself in a better position by getting an outside look at it? And look, sometimes there's enormous value in having somebody come to this having somebody, a third party, come to this who can say, hey, let's try to understand what happened. Because that's, in some ways, it can be your test audience. I see we've had a few questions come in. Joshua, you want to take a moment and we can go through some of those questions?
Of course. So the first question I have here is, who determines the amount for the claim for contract damages, the contractor or the customer/government, and how is the amount determined?
Yeah, so it's the contractor is the one that puts together the proposal and puts forward the amount that they think they are owed. Okay, so the burden is initially on the contractor to explain its position, what it's entitled to. Okay, the government then reviews that and provides a response. In the end, the parties negotiate. Okay, and if they can't come to a resolution, then FAR Part 49, in sort of the default case, will give the government authority to make a settlement decision. And if the contractor disagrees, then you have a dispute. Okay, but the burden is on the contractor in the first instance to provide the amount that it's claiming. Next question, Joshua.
Thank you, Evan. So our next question is, did you state that a FFP contract converts to a cost type contract when terminated?
So if you have a fixed price non-commercial contract, okay, Part 49 non-commercial contract, if the agreement is terminated, what you get to claim is your costs incurred up to the point of termination plus your settlement costs. And there's some conditions on that which we're going to get more into, but effectively, yeah, right? It's a bit of an overgeneralization to say that, but yes, even a fixed price contract, in presenting your termination settlement claim under FAR Part 49, you are presenting it in a cost-based way. And the cost allowability principles actually apply. So you want to think about all of that. If you have a commercial product or service contract, it's not necessarily cost-based. We got this at the very end. There's two prongs: the percentage of price for the percentage of work completed, plus reasonable charges resulting from a termination. Those reasonable charges are essentially costs, but they're just not subject to the FAR Part 31 cost principles. But again, bottom line, yeah, it effectively is like submitting a cost type proposal if a firm fixed price contract is terminated. In the default case, always read your contract. Your contract may have a clause that sends you a different direction. The default case under FAR Part 49 is what I'm talking about here.
Okay, we have one more question that I see here. And what about costs that are deemed unallowable per FAR Part 31? If those costs are incurred from a vendor as a result of termination, stop work, are the costs now allowable?
So I want to answer that question with a question, which is it the vendor's cost or the prime's cost, right? So in other words, is it the prime's cost of this vendor is unallowable, or is it that the vendor has a cost? Because your vendor's termination clause, so basically if the prime contract is terminated, then the prime is responsible for terminating subcontracts and vendors. You look at the agreements with the subcontracts and vendors to determine what they are owed. Those costs can depend, the allowability of those costs can depend on those contract terms, okay? So at the prime level, you're always looking at, are the prime's costs allowable? What are the costs to the prime, okay? If the prime has fixed price commercial subcontracts or vendor agreements where the vendor has a termination claim, a legitimate termination claim that is not cost-based, well, then you may be looking at something else, right? Then the cost to the prime may be whatever the vendor was providing, right? The supplies or services, which may be allowable. What's behind the buildup of that to the vendor, whether you look at that, depends on the terms of your vendor termination. So let's go to.
So Evan, they did provide additional context, and it was vendor's cost to contractor.
So it's the vendor's cost. So cost incurred by the vendor, where the vendor is charging on a cost reimbursement basis to the prime. So then the question is does the vendor agreement use the FAR Part 31 cost principles? Right? Did you flow down the standard cost reimbursement terms to that vendor? If yes, then the Part 31 cost principles can apply. If not, the government might still be curious about that. The government sort of starts on reviewing cost reimbursement at that point. And look, in a lot of cases, your subcontract termination claim is going to be cost-based if you flowed down the standard FAR Part 49 termination clause to a vendor or a subcontractor. So in that case, again, it all comes down to the terms of the subcontractor vendor agreement. Okay, let's go to the next slide. We already talked about this one. So when we're talking about costs, we're talking about allowable costs, okay? Cost allowability is a concept set out in FAR Part 31, and it has several components, okay? Costs need to be allowable under the principles. They need to be consistent with contract terms. They need to be allocable to the terminated contract. That means fairly assignable to the terminated contract. They also need to be what we call reasonable. This is a concept in FAR 31201-3, determining reasonableness. Costs are reasonable if, in their nature and amount, they do not exceed that which would be incurred by a prudent person in the conduct of competitive business. What does that mean, right? Not all that intuitive. You read that sentence. What is that saying? So that's saying in two parts. The costs need to be reasonable in nature and amount, meaning they need to be a sort of cost in nature, and it makes sense that it's reasonable for a business to have incurred, right? The government there is wondering, did the contractor really need to incur this cost? Would the contractor have incurred this cost in the ordinary course of business? There's also amount. Reasonable in amount means, is the cost too high? Okay, did you get a good deal? So it's two parts of that. There's no bright line rule or single test for this. There are actually several factors, which I have here. And I'll just read them because I think they're very important. Whether the cost is of a type generally recognized as ordinary and necessary for the conduct of the contractor's business or performance, right? For example, contractor often needs a lease on a corporate headquarters. That lease has costs. You got to have some place where you're running the business. That's the sort of cost that seems pretty reasonable at the outset, right? Probably perfectly normal cost that a contractor would incur regardless of whether it was doing government business. But let's say the contractor wants to have an Olympic swimming pool for the use of one employee just for fun. I don't know. The government might question whether that's reasonable, right? And who knows, maybe the contractor would say, hey, we need the Olympic swimming pool for the following business reason, but it's thinking about what are the business reasons for the costs you've incurred. 2, generally accepted sound business practices, arm's length bargaining, and federal and state laws and regulations. That's about, compliance with law and driving a good deal. Did you go out and bargain and get a good cost here? Did you get an outrageously high quote from a vendor and just say, hey, we'll accept it because we're just passing it along? The government wants to make sure that the contractor was acting reasonably, right? So that's getting at that. Contractors' responsibilities to the government, other customers, the owners of the business, or the public at large. That is more like a public policy type factor. That's a little bit harder to narrow down. And then any significant deviations from the contractor's established practices. Does the contractor normally do something one way, but it did it this other way only once just because it was a government contract? Again, the government's just trying to make sure that this is the sort of cost a contractor would ordinarily incur. So that's the basic rule. Going to the next slide, we're going to get into this in a little more detail because this is a really important concept as you go through preparation of a cost-based proposal. Oh, wait, I'm sorry. We'll come back to this, actually. There's another point I want to talk about, which is allocation of costs to contracts. Allocation is the concept of assigning a cost that you've incurred to a particular agreement. Costs are either direct or indirect. A direct cost is incurred specifically for a government contract. If you buy materials for just that contract, they're not being used anywhere else, you bought it just for the performance of this agreement, it's probably a direct cost. If the lease, for example, the corporate home office lease, that's probably benefiting all of your work. If it's benefiting a government contract, it's benefiting other parts of the business. Maybe you have private sector contracts, something like that. That kind of cost, the government wants to see ratably apportioned to all of your cost objectives, contracts, projects. So that would be an example of an indirect cost in the typical case. There actually is some flexibility and discretion for a contractor to decide what it wants to treat as direct versus indirect. But you need to be consistent, and there's sort of the basic rules we have here. Again, we got some examples like if a supplier is performing work on just one contract, doing work on just one contract within the scope of that contract, typically that's direct, whereas a vendor supplying supplies like office paper to be used throughout the whole office for lots of projects, typically indirect. And as I said, there's some discretion allowed, but where people can run into issues and where the auditors can get interested is if you have costs incurred for the same purpose in like circumstances being treated in different ways. The government's really looking for consistency in accounting. So going to the next slide. So we talked about reasonableness. We talked about allocation of costs. We want to also talk about allowability, allowable versus unallowable costs. Well, FAR Part 31 has specific allowability rules, meaning specific provisions that say, as a matter of policy, the government will or will not pay for certain types of costs. And in your standard FAR Part 49 termination, these rules are going to apply to you. And again, if you've been working under a fixed price contract where you didn't have to think about this, it can be a surprise when suddenly you find yourself in this situation. You want to account for both your allowable and your unallowable costs. Why? Because your unallowable costs are important for accounting purposes. You might need to include them in a base when you're distributing your indirect costs so that they get their burden of indirect costs. It's an important part of total time accounting if you are using total time accounting, and you don't have to, but a lot of companies do. Sometimes you actually specifically need to identify them for the government. There can be cases where you need to do that. So you want to track what costs are both allowable and unallowable. So what are some examples of unallowable costs? I've got just a few here. The classic example is alcohol. Costs of alcoholic beverages are unallowable, right? And that can be true even if you think that an alcoholic beverage for some reason is actually required by contract performance. So you probably have to think up a hypothetical to get to that. But you can imagine a situation, maybe you have some kind of arrangement, where it often comes up is, say you have like an employee morale event, you have an office party or something, and you want to have alcohol for that. The government is not going to be interested in paying for that, and we'll point to this cost principle. But there's some others that are more business oriented. The alcohol one is very simple to understand. There's others that are a little more nuanced, like interest on borrowings, however represented, bond discounts, cost of financing and refinancing, capital, net worth plus long-term liabilities are unallowable under the standard cost principle. Certain costs of attempting to influence the enactment or modification of legislation, lobbying costs, right? Government will typically treat as unallowable. So that's just some examples. Going to the next slide, I think I've got a list of a few other topics that are addressed under FAR 31205, which is sort of the root where you then have the specific cost principles. So employee compensation is addressed, depreciation is addressed, independent research and development and bid and proposal costs, insurance and indemnification, material costs. If you've never taken a look at these and you think your termination settlement proposal may involve costs covered by these principles, you are going to want to give it some thought. Okay. On to the next slide. And that, by the way, is where you may need, is an example of where you may need some outside legal or cost consulting assistance in navigating some of those things. So one of the cost principles is here, 31205-42, termination costs. It covers a few standard types of costs, not all. This is not all the costs you can claim in terminations. There's other costs you can claim as well. But this covers 4 key types of costs that you may have in a termination scenario. Okay. Initial and preparatory costs, generally allowable. These are the sort of costs at the very beginning, your startup costs, right, that you were expecting to recover in the course of performance or through your price. Those can be allowable. So can be continuing costs, costs that are continuing despite all reasonable efforts. Okay. What does that mean? Well, some of your costs, as we talked about a moment ago, you may not be able to turn off right away. You may have employees who are on employment contracts that require a week or 2 notice before you can take them off the project or terminate employment. And in those kinds of cases, you may have a legitimate point to the government that, look, there are costs that were continuing. The most I could reasonably do under my employee agreements is give 2 weeks notice or give some amount of notice. And so those are costs that reasonably continued despite reasonable efforts. The question is, at what point in time can you stop costs, right? So you want to show, if you have these kinds of continuing costs, that you were making reasonable efforts to reduce them and were unable to do it. And documenting that is really important because your auditor may ask down the line, well, how do I know that you couldn't have taken more action to stop this cost? And so you want to document that. The documentation, I mean, this is, again, where having outside counsel or a cost consultant can be very helpful in thinking about, all right, how do we document what happened so that we can explain this in our settlement proposal later? Loss of useful value can be one. You may have bought special tooling, special machinery or equipment that you were planning to use and depreciate over time on the contract, and you've now lost the value of that because you've lost the work and you don't have the need for that equipment anymore. In those kinds of cases where the equipment is not reasonably capable of use in other work and you take steps to protect the government's interest, such as by understanding what loss of value there already is in it or whether the government's entitled to any credits for the purchase of the equipment, then you can claim loss of useful value. You actually can. You can claim, and that actually includes, there's an accounting concept of impairment, of a write-down. You may have actually lost value in an equipment because you don't have another use for it. The value to you may have been use on the contract, and so its value is impaired. There's a generally accepted accounting principle concept of impairment. You may want to think about that because there can be real money on the line there in the loss of useful value point that does not leap off the page when you're first thinking about termination. Another concept discussed here is unexpired leases. Unexpired lease costs are generally allowable provided you've taken reasonable efforts. And again, I'm paraphrasing, okay? You always want to read the specific clauses in your contract and the specific cost principles, but to paraphrase, if you've taken reasonable efforts to terminate, assign, settle, or otherwise reduce the cost of a lease, that cost is generally allowable. Now, I think we got a question on this very next slide about this, so let's just jump to that because we can build that out a little bit further. Joshua, is that right? Is this our next question? Oh, no, okay, we got a couple more. All right, we'll get to the next question in a moment. We'll come back to that. All right, subcontractor terminations. I think this is a really important topic here because it can take time to unpack subcontractor terminations. And in the normal course, you want to include your subcontractor termination in your prime termination, all right? Because it's a prime's cost. Subcontractor settlements are a cost of the prime that the government will review. So you want to sequence things. A subcontractor in the normal case has no contractual rights against the government upon termination of a prime contract, because the subcontractor doesn't have a contract with the government. They have a contract with the prime. So there's a chain. Government terminates the prime terminates the sub, and you then settle in sequence. The prime terminates with the sub, the government, or the prime settles with the sub, the government settles with the prime. Okay. The FAR says 49-108, again, we're talking about FAR Part 49 terminations here, that a prime contractor and each subcontractor are responsible for prompt settlement with their terminated subcontractors or lower tier subcontractors. Okay. But what standards apply to that? The FAR provides some guidance, which I have quoted here. The contractor shall settle in general conformity with the policies and principles relating to the settlement of prime contracts. General conformity with the same principles that apply to the prime. Okay. But you're, of course, going to be going through the lens of what is in your subcontract agreement, because the subcontracts are governed by state law. They're state law contracts, enforceable state law contracts, presumably, if you've got all the elements of an enforceable state law contract, which, in the typical case you would. You're going to look at what does the subcontract say happens in the event of termination. The FAR recommends, and I think it's generally good advice, that primes put a termination for convenience clause in their subcontracts that would allow them to terminate in the event that the government terminates, right? So you have that reciprocal right to terminate, because otherwise a prime could find itself in a really tough spot if the government terminates and the prime doesn't have the same right against the subcontractor. It can be a really difficult situation. So the FAR sort of presumes that you've done that, and I'm going to sort of use that assumption right now as well. If a prime found themselves in a situation where they had not inserted a termination for a convenience clause in a subcontract, that's a different discussion. Okay, we'd want to have a different discussion about that. So we talked about cost reasonableness, and that concept comes up again here, that the cost of settling with the subcontractor need to be reasonable. They need to be reasonably negotiated at arm's length. A nice way to think about this is, if the government wasn't there, if the prime and the sub were settling a termination and the government wasn't in the picture at all, what would they do, right? What would the prime do? The government's interest here is in checking that the prime is not just taking whatever the sub's demand is, sky high demand, and saying, you figure this out. Okay. If a sub comes in and says, I want, all of this amount, bottom line, that's, give me the full contract price. The prime's responsibility is to actually bargain with the sub and try to settle at an amount that the prime thinks the government will find reasonable. Okay. So the law can actually sort of put the prime into the position of having to, drive a hard bargain, which makes sense because the prime would probably do that anyway, right? So think about that question. What would you do otherwise? And a prime is going to want to document what it did in its negotiations, because that will be helpful in the settlement process with the government. The government may say, how do we know you struck a good deal with the sub? Well, you want to document. Here's how the negotiations went. Here are any defenses we asserted. Here's the strength of their claim. The sub might have a really strong claim, but the sub might really be entitled to all that it's claiming, and a hard look at it might get you to that result. And so if that's the case, you want to document that answer so that the prime can explain it to the government. But you also want to, going to the next slide, check. So you also want to check if the CO's approval is required. Right? In a lot of cases, the CO is actually going to need to approve settlements with subcontractors, and so you may need to make the settlement conditional on the CO's approval. Communicate early and often with the CO if you think approval is needed, right? Because you don't want to surprise your contracting officer. So you can get that process going. You can keep your contracting officer updated on the status of negotiations and what's going on, so that that person doesn't feel surprised. There are situations where the contracting officer can grant the prime unilateral settlement authority. A good example is your standard subcontract below $100,000. There's actually terms on that in FAR Part 49. But for higher amounts, and in a lot of cases, the contracting officer is still going to need approval. So what happens if the prime and the sub can't settle? What if they can't agree? Well, FAR Part 49 contemplates that. It allows for a dispute process. A prime and a sub may actually end up going to court over a termination settlement or arbitration, or having some kind of dispute that plays out. The FAR notes that a final judgment can be considered part of settlement costs. So in other words, if a prime and a subcontractor actually have to have a dispute, have to go to a final judgment in a court to get it worked out, well, that can be included. The FAR also contemplates that if a prime's inability to settle with a subcontractor delays settlement of the prime contract, then the TCO, that's the termination contracting officer, which frequently the government will appoint a new contracting officer to be the terminating contracting officer just to administer the termination, can actually settle with the prime and accept the subcontractor settlement from the prime settlement and reserve the government's rights. In other words, the prime and the government can say, look, we're going to set this issue aside. We've got this subcontract dispute. That's going to have to play out. Let's all reserve our rights and let that process play out. We can settle everything else in the meantime. And why might you want to do that? Well, you may want some cash flow and you may want some closure. All right, maybe most of the issues are closed out and you want to get that done so people can go on their way as much as possible. The FAR gives you some mechanisms to do that in that Part 49 situation. Okay, next slide. Okay, everybody, we have a question. I want to give everybody 1 minute to think about this. And Joshua, I don't know if you have a prompt or something you want to put on the screen. That's fine. But let's just read this question for a moment.
We do have a prompt. The prompt is just going to have the final question. So are the lease costs allowable? So we'll give everyone a minute or so to kind of read over the question. I'll read it out as well. Contractor X signed a 1-year lease on a building it needed for a new federal contract. The federal contract had a 1-year term but was terminated a few weeks after award. Are the lease costs allowable? So just like we did for the first question, if you have a response, feel free to put that into the chat.
And I'm just going to give everybody a heads up that, like so many questions in law, bright line answers can be difficult.
So we have a couple of answers coming in. We have some who chose the maybe option on the screen. I'll read the question again one more time, and that's just Contractor X signed a 1-year lease on a building it needed for a new federal contract. The federal contract had a 1-year term but was terminated a few weeks after award. Are the lease costs allowable? So some of the answers we have here, Evan, in the chat are
I see.
Most likely, depends, maybe, depends.
All right. I'll just give everybody one more moment here.
That's the kind of answer I would choose, is kind of straddling the fence there a little bit. We have need further information. All right, I'll close the poll now, Evan, and I'll hand it back over to you.
Okay, great. So there is an answer we have here that I think is a good summation of it, which is somebody responded, yes, but required to make an effort to curb costs, which I think is a good summary of the sort of overall response. So look, what I had said a moment ago is that under FAR 31205-42, costs of unexpired leases are generally allowable if you make reasonable efforts to reduce the cost. Okay. So what does that mean? If the starting point is, did the contractor really need the lease, right? Was this a reasonable cost? Let's say the performance was going to happen in Florida, but the contractor leased a building in California and can't really articulate what that lease was going to do on the contract. All right, well, that might be trouble. But let's assume it was for contract performance in Florida. You're going to deliver goods. You need a warehouse in Florida to store the goods. That makes sense. It's a good business reason. You rented the warehouse. All right. So far, so good. So far, so reasonable. Just to assuming no other facts, right? No other circumstances. But the contract had a 1-year term, so you signed a 1-year lease. Makes sense. Assuming the lease term is coextensive with the contract term, seems pretty reasonable. But it's terminated a few weeks after award. Well, what does it mean at that point? Take reasonable efforts to reduce costs. Well, I think one thing you might do is see if you can sublease it or offload the lease, right? Is there a market for subleases? Because if you put out solicitation for subleases, or you get a real estate agent who goes, hey, there's actually somebody who will take this lease and they'll pay you more than you're paying the landlord. Well, in that case, it sounds like a pretty good deal, right? You have a way of defraying your costs. And if you don't do that, I mean, if you don't even check, you can see the government saying, hey, were you really reasonable here? Again, reasonableness is not a bright line rule, but something the government can raise. Are you really reasonable here? But let's say you do that, you get a real estate agent, you put out advertisements, or you just, you have some general sense of the market where you feel like you can confidently conclude no one else is going to take this lease. Maybe contract performance was happening in the middle of the Florida Everglades and there's nobody else who's coming along, or the contract performance was happening in the desert far from anywhere and no one else is going to come along. In that case, then you might be able to say, look, I needed the lease for contract performance. I've made efforts to sublease it or otherwise offload the lease, and I can't do that, right? Maybe your lease has an early termination provision, but it requires you to pay all the rent up front right now. Well, that just accelerates it, right? That can put you in a worse situation. So, it all comes down to the circumstances. But potentially, yes, if you've made reasonable efforts to reduce the cost, mitigate the costs, and despite those reasonable efforts, you're not able to do it, then a contractor is going to have a decent argument that the costs of the lease are allowable in that case. Okay. Now, I just want to tweak the hypo a little bit. Let's say the lease was a 2-year lease and the contract was for a 1-year term. Well, then government might say, or an auditor might say, hey, why should the government be on the hook for the full 2 years when the contract's performance period was just 1 year? Maybe then only 1 year is chargeable. To show you how sort of facts and circumstances driven this can be, imagine though for a moment that the contractor's answer is, I needed the warehouse for contract performance, and there was no other warehouse. This is the only one I could find, and the landlord was only willing to lease it to me on a 2-year term. I had no choice. But government, if the whole contract had been performed, my lease costs would have been more than covered by the price. That starts to articulate a position of, hey, even if the term was longer, maybe it's reasonable. Okay? I'm just sort of showing you the nuance in that. All right, it's always going to be, and I'm just going to say it again, I can't say it enough, read your contract, read the FAR cost principles, be mindful of the facts of your specific circumstance. Okay, let's go to the next slide. So we've got a few cases here that just show this has been an issue that's been litigated over the years. In the interest of time, I am not going to go through all these cases right now. I had thought about talking through some of them, but let's just go right on to the next slide. So subcontractor costs are a big topic. Employee costs after a federal contract termination are another big topic. Okay? That's often, labor cost is often a driver of contract cost, and it can be a really large item of a settlement. So again, cost reasonableness is really important. If you've incurred a cost, why is it an ordinary necessary cost of doing business, and what did you do to mitigate the cost? If a contract is terminated and you no longer need the staff for it, you don't have anything else any other work that they can do, you may find yourself in the unfortunate situation of having to do reduction in force actions. The cost of those reduction in force actions can be, again, facts and circumstances considering, but just in your sort of ordinary case, can be allowable under FAR 31205-6G, or -6, including severance under the subsection G principle, which says that severance is an allowable cost to the extent required by law or employer-employee agreement, established policy that constitutes and in effect a applied agreement, or the circumstances of the employment. So if your state law requires you to pay severance or to give a notice period before doing a reduction in force action, you may have costs arising from that. You may have an agreement with your employees. You may have a standing agreement that calls for some amount of severance. Severance is generally going to be allowable. There actually is an exception if an incumbent is coming in and taking over the work, the person's continuing in their same position at effectively the same position, but that's probably not going to be implicated in a termination situation. Subsection G also talks about what it calls mass severance. That's abnormal or mass severance, like large amounts. This provision is written in a little bit of a confusing way, okay? It talks about accruals for mass severance being conjectural. Some contractors accrue costs in advance. They're sort of estimating their costs in advance. And there's a fair reading of this that it's talking about that. But what this, it seems to be saying is the government, if you have mass severance costs, the government is recognizing its fair share and will consider allowability on a case-by-case basis. Okay. From a contractor's perspective, I think you're going to want to engage with your contracting officer about what that means, mindful of sort of the base starting point of this rule of severance, should be allowable. So when the government says allowability on a case-by-case basis, I think a situation where you have to engage in have to pay mass severance because of a contract termination, I think from a contractor's perspective, that's the sort of situation that this clause is probably contemplating, where the government's going to want to and need to pay its fair share, right? But again, reasonableness is really key here. The government's going to want to understand, what are the costs you incurred, employee costs you incurred, why did you incur them, what steps did you take to reduce them? I also want to talk about incentive compensation. Okay, incentive compensation can be an allowable cost under FAR 31205-6F. And you might be asking yourself, why might I need to pay incentive compensation in the event of a termination? Well, it can come up because a termination requires a lot of work to administer the termination, to do the windup. You might still have to make deliveries. The government can actually terminate in large part and say, but I still want you to deliver the following, right? So you may actually still have to do work while you're largely winding up the agreement. And in that case, you may have employees who say, look, what's the long-term, prospect here? You may have employees who feel that they need to go find another position, but you may still need those people to continue work. And in a situation like that, where to maintain the workforce you need to administer the termination, you need to negotiate a deal with an employee. I think, again, it all comes down to reasonableness, but just be aware that there is that cost principle there. Now, I think the government's gonna take a look at that, right? This is not. It's a matter of reasonableness, right? Would a business in the ordinary course of business need to incur the cost? Okay. Next slide, please.
Hey, Evan, I am going to put up the second password now just because we have a little over 10 minutes left here.
Okay, great.
Our second password is CARP. Something you may notice is a little related to our first password. That's capital C-A-R-P, capital C-A-R-P. CARP is your second password. I'll leave this up for about 10 more seconds, and then after I take this down, Evan, I have it on slide 22. So I have SF 1435, 1436, 1437, and the floor is yours.
Excellent. Okay. And, just mindful, everybody, we've got about 10 minutes left. If anybody has questions, please jump in. I'm happy to answer them. We're going to have a second session toward the end of August. We'll be able to continue going through the slides. So, we're not done here, right? And I'm not going to rush through the next couple of slides. I think we'll just go through them at the normal pace, and where we stop, we'll pick up on the next session. All right. Under FAR Part 49, there are standard forms that you use in a settlement proposal, depending on the type of settlement you are pursuing. For fixed price contracts, your basic options are the SF 1435 or 1436. One is termination processed on an inventory basis. That's where you are focusing, and you have a lot of inventory, and you're going to focus on that. 1436 is the total cost basis. Both of these are cost driven, though. Okay, and filling out this form can be a little difficult. This is a good instance of where you actually may want some outside consultant assistance, a cost consultant, to help you fill this thing out, because the statement of cost here is really critical to help the government understand what you are asking for. All right, so you're going to have that narrative in your termination settlement proposal that explains what you're asking for. You're going to have your financial data, but you're also going to have this form that breaks it down. So filling out this form, very important. Wanted to make sure this is on the screen so that everybody recognizes it. Let's go to the next slide. So the termination settlement proposal process can take a while, right? Even once you submit your settlement proposal, the government may need a fair amount of time to analyze it, to understand it. In a lot of cases, particularly if it's a large settlement proposal, the contracting officer may need to refer it for audit, and that can take a while to process. And in the meantime, there may be parts of your settlement proposal that aren't controversial. There may be completed end items that have been delivered. There may be costs that the contracting officer fully understands you've incurred and thinks are reasonable. All that is to say, there just may be parts of your settlement proposal that the parties can agree on early. And for contractors who've submitted a termination settlement proposal, they may need the cash flow, right? It may be difficult for them to wait the months, or I hate to say it, in some cases even years, that it can take to process these things, although they really shouldn't take that long, I think. They should go much faster than that, but I'm aware of instances where it has taken years, unfortunately. You may find yourself in the situation of needing some cash flow, and it can also be to the benefit of the government to get some final resolution. Say there might be a subcontract dispute brewing, and if you can pay the subcontractor and sort of, resolve that, it'll smooth the process overall. The FAR contemplates a process for requesting partial payment. FAR 49112-1A explains that if the contract authorizes partial payments on settlement proposals before settlement, then the prime can request them. And there's a form for requesting them. It's prescribed in the FAR citation I have here, at any time after submission of an interim or final settlement proposal. So you've submitted the proposal, you're still negotiating, you don't have a final answer, but you have some amount that you think is uncontroversial. You can submit a partial payment request, and the government can process that. The government's supposed to process the request promptly, and if you have subcontractors in the same situation, you can have the subcontractors flow the request up, okay? So, the government, though, ultimately has discretion on deciding this, and that discretion is important because, well, for many reasons, right? The discretion is critical. It's the government's judgment. But if in the final resolution of the settlement, there's a determination that the amount due is less perhaps than partial payment, then you can be in a situation where the government needs a refund, right? So everyone should be really mindful. If you're requesting partial payment, what's the amount justified? Is there any chance that there's going to be a final settlement that's for less than the partial payment amount? Because if so, you can expect the government to request repayment plus interest. That can be very complicated too if prime is flowing partial payment requests through a subcontractor, all right? Because the prime is going to need to protect its interest vis-a-vis the sub if there's a request for a refund later from the government. This process is really powerful, can be really helpful to all involved, but can be complicated. And if you are going to pursue it, you want to be mindful of everybody's rights along the way and make sure you are negotiating a process that is fair and reasonable for everybody. So let's go on to the next slide. And I saw there was a question about, is there another slide deck for part 2, or will we pick up? So we will pick up on the remaining slides, and then we're going to have a few new slides in the next session, is the answer to that question. All right, adjustments for profit on fixed price contracts. So we've been talking about cost. What cost can you claim? Very important subject. It's also in every contractor's interest to get profit, and profit actually is allowed on termination settlements. But as you won't be surprised to hear, there are rules. So the basic principle is that fair profit is allowed on preparations made and work done by the contractor for the terminated portion of the contract, but not on the settlement expenses. Okay, so that requires you to look at your costs, break them down by type, and claim profit only on the types that are eligible. Profit is generally claimed as a reasonable percentage of your cost. Okay, profit here does not mean your anticipated profit. Okay, so you may have thought, hey, this is a fixed price contract for $100,000. My costs are going to be $90,000, and so my profit's going to be 10. All right, that may have been what you thought going in as your plan, but it's terminated early. It's terminated right away. Maybe it's terminated on the very first day. The FAR says that a contractor cannot claim its anticipatory profit. Instead, it can claim reasonable profit on the cost incurred. Okay, so that's different from anticipatory profit. It's different from lost profit. It's different from consequential damages. It's a profit on the cost incurred. So for subcontracts, you can claim profit on the amount of effort in the settlement, but not on the dollar amount of the settlement. Okay, so that's it's not that the higher the settlement, the more profit. In other words, is what that rule is saying. There's also not profit on material and services that, as of the effective date of termination, have not been delivered by the subcontractor, regardless of any sort of percentage of completion. So that's, I think, the government anticipating, well, what sort of clause might be in the subcontract? What's the subcontractor's basis for claiming a termination settlement? So how do you decide the rate? What's the right rate of profit to claim? Well, that's something that you need to establish as reasonable, considering a variety of factors. We've got some of the factors here: the difficulty of the work done, the efficiency of the contractor. These are a lot of the same factors that you actually see in Part 15 of the FAR, and that in the discussion of what is a reasonable rate of profit on a contract. But it's something that can be negotiated, and it can actually depend on events that happen since termination. All right. The termination process and the work necessary to do a termination can be part of that. And I think that's a really important thing to remember here. So you set a rate, you negotiate a rate that you then apply. But there's a nuance, a really important nuance that I wish we had actually more time to talk about. I will just get started on it and then I will pause. So if you go to the next slide. And Joshua, I don't know if there's a third password that you need to do, if maybe now's a good time for it, or if you want to wait to the end. I can just do this slide and then I can stop. Let me know what makes sense, Joshua.
That works for me. You can do the slide and then I'll do the third password.
All right. So FAR 49203B and C sets out a general principle that there is not profit for the contractor in a termination settlement if it would have been in a loss position. So there's this very general concept of not using a termination settlement to get into a better place than if the contract were fully performed. And as a result of that, the government, the FAR rather, has some rules to account for what would be the case if the contractor is in a loss position, right? To decrement profit to the extent, and sometimes decrement profit in cases where the contractor wouldn't have had any anyway, right? So there's sort of two different amounts or two different sort of main mechanisms for that, depending on whether the settlement's on an inventory basis or a cost basis, but the same idea is at play in both, of decrementing based on whether the contractor was in a loss position, which can be a difficult thing. It's a bit of a counterfactual, and we'll talk about that a little more when we pick up next time. So let me pause there to give Joshua a chance to do that last password.
All right. Thank you so much, Evan. I want to thank everyone for joining us today. Like he mentioned, this is the first of a two-part workshop. So we do have one question here that says, do you have to use one of the settlement proposal forms, or can you send the settlement proposal quote in the form of a letter? Before you answer that, I will put up this third password for anyone who has the hard stop. That third password is Goldfish, capital GOLDFISH. And that question was, do you have to use one of the settlement proposal forms?
Yeah, so there are actually, again, always look at your contract, but there are certainly cases where you do have to submit the form, where the FAR Part 49 instruction requires you to select the appropriate form. In a commercial termination context, you will not necessarily have to use one of the forms, and you may have language in your contract that lets you do something else, but those forms are really important. It's also something that the government's just sort of expecting to see as their experience. So look, with that, I'm Evan Sherwood, again, partner at Denton's. My contact information is at the front and the end of the slides. I really appreciate everybody being here today, getting a chance to answer your questions. If you have questions, you got my contact information. And otherwise, I will see everybody at the next session next month. So thank you all very much. Again, I'm Evan Sherwood. Have a nice day.
Thank you so much, Evan. Thank you, everyone, for joining us. We will see you at the next session. Like he mentioned, his contact information is in the deck. If you have any questions for me regarding password certificates, feel free to email me at joshpina@publiccontractagency.com. Evan, again, thank you so much. Have a great rest of your day.
Great. Thank you, everybody.
Thank you, everyone.